Our conversation of stockholder rights next moves to a conversation about stockholders' ability to sue in a substantive manner. We talked about shareholder rights to sue procedurally, the difference between direct suits and derivative suits. And we focused on the demand requirement with regard to derivative suits and when that would be excused and what is the role of special litigation committees. We touched briefly on adequacy and standing. But in order to have a lawsuit, we actually need to have some kind of substantive basis. And one substantive basis is a breach of the duty of care. So these are all going to be suits against directors for breaching one type of duty or another. Suits against directors for breaching one type of duty or another. And so we'll first talk about the breach of the duty of care. And we're going to learn about the business judgment rule and the concept of judicial abstention. And we're going to see an illustration of that in the case of Wrigley, SHLENSKY versus Wrigley, an interesting kind of case about night baseball. And then we're going to talk about the reasoning behind the business judgment rule in a little more detail. It's more than just deference. And some exceptions for fraud, illegality, and conflicts, which also relate to some of the other lessons on 10b-5 securities fraud and also relate to duty of loyalty breaches. There are, of course, exceptions to every rule. We'll talk about those. And then we're going to come to whether or not boards have to do anything in order to qualify for this protection. And the answer apparently is yes. If boards fail to go through a certain amount of paper and process, if they make decisions too quickly or without sufficient information, they may not be able to enjoy the protections of the business judgment rule. And so we'll have to talk and see how that plays out a little bit. And we have kind of a major case that really shook and shocked the corporate world in Smith v. Van Gorkom. So what are fiduciary duties? Where do they come from? Agency law. Right? So fiduciary responsibilities grow out of agency law. That's why we spent some time learning about agency law and why many courses will have a separate course really on agency and partnership, because those are all the predecessor concepts that lead to fiduciary duties. In most basic terms, fiduciary duties are obligations that agents owe to principals. And in the case of corporate fiduciary duties, we have our directors and officers. Those are the agents, and they owe certain duties to the principals, the shareholders, and one of those is the duty of care. And to say it simply, and we'll have to see it in several examples for this to make more sense, the duty of care requires corporate agents to act honestly, in good faith, and in an informed manner. That's basically it. And if they do so, their protections are generally protected from judicial intervention. And that's why we call this a document of judicial abstention. So if directors and officers reasonably believe they're acting in the best interest of the corporation, and there may be some kind of objective view of that as well, the duty of care will protect them from lawsuits and mandate dismissal of a case against them. As we'll see, though, as we move farther into this, the line between duty of care and duty of loyalty can be a little bit blurry. And so we're going to try to tease that over the course of the next month of lessons on this. What exactly falls into which bucket? Some things are more clear than others. And concepts like waste are clearly in this bucket until the waste is by giving a grant to your wife, right? And then there's a duty of loyalty concern because you are now interested. So basically the business judgment rule is going to protect business decisions by boards, at least most of them. Business decisions. It's this kind of like a gross negligence standard that boards are allowed to even be negligent and still not be liable. But this rule that effectively protects directors from anything short of gross negligence does not apply when the directors have a conflict of interest. Because when they have a conflict of interest, or we could put it another way, when there's duty of loyalty concerns, then why are we confident that the directors are acting on the best interest of the corporation? And they sort of lose the business judgment rule presumption. So it's important to remember that the business judgment rule is a presumption and a rebuttable one at that. It's a rebuttable presumption insulating directors, but it can and sometimes is rebutted when a shareholder sets forth a claim that the director did not operate with sufficient process. And that's going to really be the issue we're going to push on. And by the way, then we're going to move on to that and talk about the duty of, what I call the duty of oversight, which might also be a sort of an omission. So when we talk about a breach of the duty of care, it's a commission, an affirmative action that did not rise to the level of business judgment because it did not have enough process behind it. We're also going to talk about omissions, failures to put safeguards into place, which can rise to liability. And that's what I call the duty of oversight. So where does this doctrine come from? Right, this doctrine of judicial abstention. It comes mostly from case law. There's no real statute on point. There are some principles, though, less so under the Delaware Code, but we can look to the Model Business Corporations Act for at least a capture of this. The Model Business Corporations Act, Section 8.30, talks about standards of conduct for directors. And it says that each member of the board, when discharging the duties of a director, shall act in good faith and in a manner the director reasonably believes to be in the best interest of the corporation. So we have two very clear principles, well, not so clear, two very succinct at least: good faith and in a manner that is reasonably believed to be in the best interest of the corporation. And if you do that, you're probably acting within your duty of care, or at least it would seem so until Van Gorkom. But this raises some questions. What is a reasonable belief, right? What will get you as a director to the level of having a reasonable belief in what you're doing is in the best interest of the corporation? That may require you to do some digging through your information. And what are the best interests of the corporation? This is also an open question. We talked about this last semester. Are the best interests of the corporation solely to maximize profits? And are those to maximize short-term or long-term profits? And if something else, what else? What are the other objectives of a corporation? So this seems to give directors a wide range of activities they can engage in without becoming liable, although that has been curtailed a bit more recently. So, as I mentioned, this is a doctrine of judicial abstention. Judges will not second-guess director decisions that are within what we'll call the realm of reason, and directors must be at least grossly negligent, effectively, to be liable. And the plaintiff is a rebuttable presumption. The plaintiff, though, bears the burden of rebutting the presumption by showing the directors engaged in self-dealing, acted in bad faith, or made a decision that's not a proper exercise of business judgment. So, why do we have this rule? Well, judges are not business experts. Judges are generalists. Delaware courts are closer because Delaware courts generally hear corporate matters all the time, day in and day out. But look, most courthouses, you could have a divorce followed by a corporate action, followed by a murder trial. Right? Judges, by their nature, are generalists, and it's not their job to dig in on all the specifics of one particular business anyway. That's the director's job. It's not even the shareholder's job. The directors are the ones that are supposed to be the experts in the business, and so there's a reason for judges to defer to them. The potential for board decisions being subject to judicial review makes, however, judicial decision-making, the fact that courts can and sometimes do supplement and supplant board decisions with their own does create some tensions to this basic rule. So, you know, it has its negative effects, because the more that we allow this type of shareholder litigation, we would think the more we'll prevent directors from acting badly. But at the same time, we're taking power away from directors, we're making them nervous, we're encouraging them to take fewer risks, and so we need to strike some kind of balance. Let me tell you the story of SHLENSKY versus Wrigley, and let's see if this is more clear through an illustration. I really like this case, partly because I lived in Chicago and I had a view from my apartment of the Cubs stadium. And so there's a couple things about the Cubs stadium that are worth mentioning at the outset that make this case kind of special. For one thing, it's one of the older stadiums that are still being played in. I don't know, by the way, are there any baseball fans or Cubs fans here? Yeah? Just baseball. Do you know anything about the history of Wrigley Field? One thing that's very distinctive about it, even compared to where the Pirates play, is that it's right in the middle of downtown. And, well, I shouldn't say downtown, like with the skyscrapers, but it is in a very urban area. And it always has been. And that's kind of unusual. I mean, if you've been to a lot of baseball games, most are not in the middle of densely populated urban areas. If you are in the neighborhood, the adjoining apartment buildings have visibility into the stadium, and you can actually get seats there. I don't think the Cubs get paid for, I don't know the details about but it's truly unique stadium. And one thing that was unique about it for quite a while was that they only played baseball in the daytime. They only played baseball in the daytime. Why? Well, they didn't have lights. Yeah, but why didn't they have a chicken egg, right? Yeah, they didn't build lights to play at night, but they did that deliberately. They didn't want to play night baseball. So the team was controlled by Wrigley, Philip Wrigley of Wrigley Gum, right? And he owned 80% of the stock and was president of the baseball club. And he effectively refused to install lights or host night games. And some of the shareholders didn't like it. In fact, one named SHLENSKY, didn't like it and decided to sue, basically claiming that the Cubs were able to make more money than they were actually making by not playing night baseball. And let's look at the circumstances. So it's 1968. So what's happening in 1968? Well, one thing that's happened. Well, a lot of things. You don't know where I'm going with this one, right? So you could say I'll give a little more guidance here, right? So what's happening to urban areas in white flight, right? The concept, the term used is white flight. And so in this period of the 60s, there's a lot of civil unrest. We're in a Vietnam era. There's various protests, what have you, going on. The extension of the suburbs. I'm picturing wood-paneled station wagons going off to the suburbs every day. And so we have this very important period in the evolution of the urban core. And unlike the case of Ford, where Henry Ford basically said, I hate my shareholders and I want them to have less money, Wrigley said something a little bit different. He effectively argued that A, baseball is a daytime sport and we're honoring the sport, and B, installing lights would hurt the property values in this neighborhood and would inure to the detriment of the team. And so he alleged, he claimed that this was a business decision, a valid business decision. Wasn't wasteful. And I think if we look at it through the perspective of what was happening in 1968, if we look at the population, the population of Chicago is divided. I lived for several years in South Side Chicago. It was in a little enclave called Hyde Park, but in general, South Side Chicago is heavily African American and very poor. And it's one of the areas of high gun violence, as well as a number of other problems, including lack of grocery stores and access to nutrition, poor schools. I mean, it's in a bad way. North Chicago, I also spent a year living in Lakeview, which is where I was able to see the stadium from. It's completely different. I walk around in the middle of the night. It's fairly expensive. Is boutique grocery stores selling Asian pears and fancy teas, right down the main street. Totally different demographic. And there are two different teams. There's the White Sox and the Cubs. And generally, the Cubs on the north side and the White Sox on the south side draw a demographic not totally different from the neighborhoods in which they reside. I think part of the backstory here was Wrigley was concerned about maintaining the demographic, who at that point was not comfortable going into the city at night. My father grew up in Washington, D.C., and his mother as well. And it used to be that you left the downtown area at 5 p.m. You didn't stick around. I mean, you remember living in an environment like this, right? And there was just so maybe night baseball was different for the Cubs. And maybe this concept of this social morass that they found themselves in. I think that's part of what led the court to its decision. So we have this claim, however, that Wrigley is committing waste and effectively not acting reasonably because he is refusing to have night baseball, and SHLENSKY a shareholder wants to cause him to change that. So he alleged waste, which, as we've talked about, requires a showing that there is no rational basis for a decision, and filed a derivative suit. Yeah, right, a derivative suit, because waste claims need to be filed derivatively. It would be improper to file a waste claim with a direct action because it's a harm to the corporation. and argued that it was not in the best interest of the Cubs to continue this practice. So what came of this case? Now, this was what year? Case 1968. So, you saw kind of where we were in the evolution here, right? And I'll give you a hint. We're sort of in the era of Auerbach, right? So what do you think came of this case? Was SHLENSKY able to proceed with his case, or was it dismissed? The case was dismissed because SHLENSKY did not state a claim. That's the standard for motion to dismiss being granted. Failure to state a claim on which relief can be granted. He did not claim there was fraud. He did not claim there was illegality. He did not claim there was a conflict of interest. Those are things that would disrupt the business judgment rule presumption. But without a claim, an allegation, pled with particularity, I guess, under these standards, of fraud, illegal conduct, or a conflict of interest by the director, we don't have a claim. So the case is going to be dismissed. And the court actually elaborated on this and talked about the grounds for dismissal. Courts, at least at this era, will not speculate as the validity of a director's business judgment so long as there is any rational belief. Right? So this waste claim, right, what does it require? You have to have no rational basis for making a decision. You are literally taking money and setting it on fire and not even claiming it's going to keep you warm. I mean, again, we're talking an extremely difficult claim to prevail on. The court held, it appears to us that the effect on the surrounding neighborhood might well be considered by a director who is considering the patrons would or would not attend the games, the long-run interest of the corporation, and the property value at Wrigley Field. Demand all efforts to keep the neighborhood from deteriorating. Just thinking about the context here, the court recognizes that the patrons may not be attending night baseball, and it's important to balance this interest, or at least there's some, it might be wrong, but it's not irrational. Very minor standard, very low threshold for the director to get protection. There is no allegation there will be a benefit to the corporation from night baseball, considering all increased costs. I think that was a kind of a foul ball from the court on that one, because again, the plaintiff does not have to affirmatively show the corporation would make more money, but no mention was made of the cost of the lights and whether it would increase or decrease profits. So the court seems to be hemming and hawing about whether or not they would get involved in the business judgment. And so we find here a very clear standard in favor of the business judgment rule, and it effectively says if there is no allegation of fraud, illegal conduct, or a conflict of interest, the claim effectively will fail, unless there is no rational basis whatsoever for the action that the director took, which is an almost impossible standard for the shareholders to meet. And by the way, just I think it's an interesting story. What happened afterwards? And I was actually there for part of the story. So Wrigley vowed that the Cubs would never pay night baseball. And he left his share in the corporation, which, by the way, if you're an 80% shareholder, that is control, right? It's more than 50%. You're going to be able to nominate the directors and actually run the whole thing, to his son. And he told his son to promise him to uphold his mission to never allow night baseball. The son, in turn, I guess was not interested in running the team, sold the team in 1981 to the Chicago Tribune. So we have a newspaper who owns a baseball team, and the Tribune actually fought a Chicago city ordinance. So I don't know the exact relation between the ordinance and Wrigley, but there was an ordinance in place that prohibited night baseball in the city limits of Chicago. So the Tribune fought this, and in 1988, the ordinance was rescinded. In August of that same year, the first night baseball game was played at Wrigley Field. And by the way, the image here, I'm sorry, doesn't come out very well. You can see the lights now mounted on the stadium. There are definitely lights there. I've seen them illuminated at night. And, this might have broken the Billy Goat curse. I assume you all know about the Billy Goat curse, right? That's right. A man brought his pet goat to the stadium for a World Series game. And he had a ticket, but he was denied access because it was a goat. And you can't take a goat to a baseball game. So what did he do? He didn't just walk away. No. he put a curse on the team, the infamous Billy Goat curse, cursing them, they shall never win another World Series. And that curse was finally broken in 2016 when the Cubs won their first World Series since 1908. I don't know, was it because of night baseball? So anyway, that's the story of Wrigley. And really, it's a fun story, but it also introduces some of the dimensions here. I think it makes a couple key points. One is that it's hard to understand what constitutes a valid business judgment. You may not, as a court, recognize and appreciate all the details about the zeitgeist of white flight in 1968 and the relationship of the Cubs to this location and how the lights and every other aspect of it would change the dynamic of the team and the relationship of the fans to the place. That's why we have directors that make these decisions. And under the standard evidenced here, so long as there is a rational basis, as long as there is a rational basis for the decision, and so long as there is no allegation, valid allegation I should say, of fraud, illegal conduct, or a conflict of interest, that rational decision, so long as it has a modicum of rationality to it, will prevail. However, it's not entirely clear that this rational basis standard still prevails today. And courts have moved toward a reasonable basis type of test. It's not, again, entirely clear. It's not entirely clear that this is different, but the Model Business Corporations Act discusses a reasonable basis. So at least in some other states and not Delaware, it seems like reasonable is more than any rational basis. Any rational basis does not seem like it requires a balancing act. It's sort of like if you have any reason in a whole, there's, it could be 10 to 1 against, but you still got one good reason. That means you have a rational basis, any rational basis. Where there's a reasonable basis, might require more of a weighing and balancing, and this decision is more good than it is bad. So the Model Business Corporations Act talks about a reasonable basis and suggests that in an MBCA jurisdiction there would be a higher degree of director accountability. And so in SHLENSKY, the standard was based on rationality. While a reasonable director might have had night games, daytime games only were not completely contrary to all reason and logic. So a rationality standard could allow additional discretion. A reasonable standard could allow additional court imposition, whereas a rationality standard allows additional director discretion. And just as a reminder, why wasn't this claim waste? Waste is very, very hard to show. It almost never prevails because it requires only any rational basis for a decision. So kind of coming back to our policy rationale or explanations of why the business judgment rule, well, judges are not experts in business. And the potential for board decisions being subject to judicial review would make it hard to know that a corporation will be able to enact a policy. And so the desire to have certainty around board decisions is another reason for judicial restraint. Without judicial restraint, financial planning, long-term planning, confidence that directors can set an agenda and stick to it would be impossible. And so it seems necessary to maintain the corporate structure as we understand it. And maybe it encourages risk-taking. And risk-taking is not a bad thing. I mean, without risk, you don't have reward. So having some amount of risk-taking is appropriate. So that was the state of the world for quite some time. But the case of Smith v. Van Gorkom came about, and Smith v. Van Gorkom really changed how people felt about the risks directors took when they made business decisions. So what was happening in TransUnion? TransUnion had a very unusual problem. What problem did TransUnion have? Yeah, they had tax deductions they couldn't use. So if you incur losses in the past, you can carry those losses forward. They expire at some point. I'm not a tax attorney, and I don't pretend to be one. I don't want to be. It's very following the tax code every year is even more interesting than this, I assure you. But they had tax losses. They didn't have anything to do with them, and they were very valuable, and you're going to lose effectively. It's like having a coupon or a discount that's expiring. Yeah? So they had all these benefits they couldn't use, at least with their current business. And it's actually kind of interesting. Well, I don't know if it's interesting. I think it's interesting, which means it's probably not very interesting, how they came about having these losses. What did TransUnion do? You can see what they do now. I don't think they're in this business anymore, but TransUnion was originally in what business? The name is a hint, yeah. Railroad business, yeah. They actually ship stuff across this great union of ours, right? From the East Coast to the West Coast, they were shipping stuff, and as a result, they had a number of rail cars. That's how you ship stuff. They own the rail cars. Now, rail cars are real property, and real property depreciates over time. Now, we have real depreciation, meaning if you have a rail car today, it'll be worth less tomorrow than today, aside from things like the value of steel, what have you. But most cars, most devices, most sheds, most homes depreciate over time. And you're allowed to collect deductions from that depreciation. But the depreciation from the actual item, like its actual loss in value, does not necessarily have any rational relationship to the book depreciation. And so the ownership of all these rail cars entitled them to some tax credits that could be applied against tax income. They didn't have enough income to use the credits, and as a result, they were going to use it, to lose it, rather. So what can they do about this? What are some options or some solutions that you could do if you have some losses that you can't spend? You could buy a profitable business. Now, the thing is that if you have a bunch of tax credits and there's a business that has a lot of income, acquiring that, effectively merging with that company, means that your value of that company is higher than their value of their own business. So one thing you could do with this money you're sitting on is acquire a business and generate some taxable income. So that sounds like a pretty good approach. That's one option. What's another option? TransUnion is a big company. They could lobby the government and try to get those unused tax credits to keep on their books. I mean, Congress can do a lot of, you hear about this all the time. Apparently states gave Amazon a real sweetheart deal for HQ2, however you want to call it, right? And so states have a lot of flexibility to negotiate tax policy, and you could potentially go to your Congress and get cash for the unused credits. Instead of buying a company, what else could you do? Yeah. Sell the company, which is instructive for how the case played out. And why is that? Because the company that buys you gets all of your assets, including your tax credits. So while you could buy a company that generates profits, you could also be bought by a company that is profitable, and your tax credits would offset their income, and they get more bang for their buck. They get a business, and they get tax credits that they can use. And there are different ways to sell yourself. You could sell yourself to a private company. You could sell yourself to a public company. You could offer a management buyout. But there are different kind of approaches to either buying or selling a company. But you need some kind of merger activity or effectively an act of Congress to do something productive with these tax credits. So the president, who by the way is Van Gorkom, Jerome Van Gorkom, decides to sell the company. So Van Gorkom was chairman and CEO of TransUnion. And he actually has an interesting backstory. Again, I think interesting. He was raised during the Depression by a mother on welfare. And he went to the University of Illinois, earned a law degree, then served in the Navy during World War II. After his service, he entered private law practice, worked for Arthur Andersen as a CPA, and then became comptroller of Union Tank Car and was eventually named CEO and director of TransUnion in 1963. Kind of an interesting history. I mean, coming from deep poverty, raised by a single mother on welfare, got a law degree, service in the military, was also a CPA, so understood accounting, and interestingly was about to retire. We'll come back to that, right? The fact he was 62 and about to retire. And so he believed the sale of the company would resolve the problem. Let's sell the company, and that's going to solve our problem. So what did he do to help get this process going? So the rest of the directors, by the way, were really impressive people. At least seemed pretty impressive. We got A.W. Wallace, who is an economist, the dean of the Chicago MBA program, chancellor of the University of Rochester. William B. Johnson is a lawyer, a CEO. Joseph Latterman is a CPA, CEO of American Steel. Graham Morgan's a chemist and CEO of U.S. Gypsum, who had done 31 corporate takeovers. Robert Renneker is a Harvard MBA and a CEO. And these are all the outside directors who are theoretically disinterested. So they're not dummies, right? And then on the inside, you've got fairly competent people as well. So we get all these folks together and we have a meeting. Makes sense. What happens at the meeting? A 20-minute presentation by the CEO who had, on his own accord, made a social connection and settled on a $55 price. What evidence does the board hear that that $55 price is a good price? I mean, that's what they should care about. Their job is to maximize shareholder value, right? We can all agree that they can't minimize shareholder value. I mean, this is not a corporate social responsibility type CSR, SWM comparison. How do you maximize value? You get the best price. How do they know they had the best price? They asked their comptroller, is that right? That they basically asked the comptroller, said, yeah, that sounds good. 50% is a big number. Okay, not so great in terms of the information. So problems, right? We have problems with the process from day one. The director, the president, Van Gorkom, is kind of going outside the normal channels. He's got a deal going on where they are disincentivized to shop the company and get a good value. The board meeting includes a 20-minute presentation. Hey guys, you should totally take this deal. It's awesome. I came up with it. I'm really smart. I'm cool. I know numbers. And so you should listen to me. I mean, 20 minutes, that's like 1/15 of my class period, right? It feels like that sometimes, right? So it's a very short meeting, 2-hour meeting, where they ostensibly hear a couple other presentations, and they eventually come up with this plan that is supposed to get them a good value. And what is the plan? The plan to try to figure out if this value is good. The board isn't quite rolling over just yet. They didn't just sign on the dotted line. Yeah. So they want to be able to shop the company. They want to be able to shop the company. And so that's a great way to know what something is worth. We've got one in the bag for $55 a share. Let's go out there and see how much someone would pay for it. And we call this the market test period. Now, that actually does make some sense, right? I mean, if you go out, if the question is how much is this company worth, how do we find out? The best way to find out what something, and by the way, the adage is what's something worth? It's worth what someone will pay for it. I mean, there are things that are very common, and so we know what people generally pay for it. You can go on eBay and find out how much someone is paying for a 2016 iPad Pro. There's a number for that, and it's probably pretty clear within some kind of a range. TransUnion, what's its value? Look, that's more complicated. You saw the module last semester. We talked about different methods of valuation, but it's definitely more of an art than a science. Best way to know what something's worth is to see what someone will pay. So they're going to shop the company, and they actually had some success in that, right? So they shop the company, and they get 2 seemingly serious offers, one from General Electric, which we saw before, and one from KKR, an investment firm like BlackRock. But both of them needed to figure it out within the 90-day period, and it just wasn't worth their effort. That period apparently was too short, at least according to the court, to get a real market test. 90 days is not a long time to shop a company like TransUnion to see who wants to buy it. So the board effectively signs off on it, provided that they have the right to accept a better offer during this 90-day period. No better offer comes during the 90-day period. And so they want to, make sure that they're on the up and up here, so they go through yet one more step in the process. They call a shareholder meeting, and they say, hey, shareholders, how about you approve it? Because if you approve it, you can't sue us, right? I mean, that actually makes some sense. If you had any question about whether the deal was valid, you put it to a vote. So after the test period ended, the board approved the merger, issued a proxy statement, called for the shareholders to support it. Some of the shareholders filed suit at that point in 1980, but a majority of shareholders approved the transaction. When the test period was over, the board gave final approval. The shareholders approved the merger. Why did they approve it? Let's say you have stock that's worth $38 a share, and you're told that it will turn into $55 a share. Does that sound good to you? Sure. Sure, you just made a 50% premium, right? Are you a financial expert? Do you know what TransUnion's worth? Do you trust the board? Do you trust the board to be working for your best interests? So there are two things at work. One, maybe that number sounded good to them too. 50% is sort of a nice round number, sounds positive. Maybe they're sheep. Maybe they just follow along with the directors because they trust that the directors will work in their best interests. So, the lower court found that the board was protected. The lower court found this, and of course this does get appealed, and ruled that the board's actions were protected by the business judgment rule because the board was informed. It's an informed decision. It was a business judgment rule. The board was free to turn down the Pritzker proposal. They didn't have to do it. They actually looked at the offer 3 additional times. No legally binding agreement was reached, so the company could have backed out at any time. And if a higher offer was out there, the market test would have produced it. The shareholders, the ones who complained, appeal. The court got it wrong. So, did the board satisfy its duty to become informed such that it was protected by the business judgment rule? Did the board win, or is this the limit of the business judgment rule? They were not protected by the business judgment rule. Wow, no business judgment rule protection. A total shock. A total shock. This shocked the world because rarely do we find a case where a decision like something like this, where there's no claim. Again, what were those items that we saw in Wrigley, right? And there are no claims of breach of loyalty. There's no claims of illegality. Yet, no business judgment rule protection. The court held that the business judgment rule did not apply because the board failed to become informed and thus breached its fiduciary duty of care by failure to become informed. For the business judgment rule to apply, the board of directors had to make themselves informed prior to making a decision. Thus, if a decision was made without satisfying the duty to become informed, the business judgment rule does not protect that decision. Now, why are the reasons for this? Why are we going to phrase it this way? Well, we're going to give discretion to directors, but we want to have some limits to it. Delaware General Corporation Law 141A says that the directors manage the company. The business and affairs of every corporation organized under this chapter shall be managed by or under the direction of a board of directors. And the directors then are entitled to make these business decisions without the shareholders getting involved. But apparently there are some outer limits to do this, and we have to impose upon the board a requirement that they reach their decisions through paper and process by becoming informed. And the court here holds that they did not do so. It's stern court, very angry, holding that the directors failed their fiduciary duty by failure to inform themselves. They did not get all the information necessary prior to their decision to recommend the merger, and they failed to disclose material information. In this case, Van Gorkom failed to disclose material information that was relevant to making the decision. And I think there's even an inkling, maybe, and even an inkling that there was a conflict of interest because Van Gorkom was on the outs. He was 62, wanted to retire. So he'd love to put $80 million in his pocket before he walks out the door. So maybe there was sort of an inkling that there might have been a conflict of interest too. On the record before us, we must conclude the board of directors did not reach an informed decision on September 20th, 1980 in voting to sell the company at $55 per share because the directors did not inform themselves about Van Gorkom's role, about the intrinsic value of the company, and the details of the deal. There was no investment bank valuation. That might have been an additional method, and the market test was insufficient. It didn't provide enough time. It was limited in time and scope. It was hard to get good market information, partly because they were already under a quasi-contract with Pritzker, because he had this option. The 90-day period might have scared them off. Now, the board, of course, defends and says, but court, we got a 50% premium. 50%! That's a big number. And the court says, okay, but how do you know you couldn't have gotten 60 or 70 or 100 or 150? It's just a number. Why was it the right number? It's not clear. There was a dissent. The dissent said, look, the board was experienced. They weren't fooled or bamboozled. 2 hours was all the time they needed. This was such a good deal, so obviously a good deal. But that's not enough for the majority. Now, why wasn't the shareholder vote enough? A shareholder vote can cleanse certain director improprieties. Right? So we do have a concept of a cleansing vote, and we'll come back to that. But this vote wasn't sufficient to cleanse it. Why? The shareholders were no better informed than the directors were. They had the same crap information with some made-up number, 50%. So the directors can only have their malfeasance cleansed by a shareholder vote if the shareholders are operating with sufficient information. And the shareholder vote was also uninformed. The case was remanded to the Delaware Court of Chancery to conduct an evidentiary hearing to value the stock at the date of the board's decision, and an award of damages will be provided to the extent that it exceeds $55 a share. Now, this is hard. You have to go back into history and figure out what a company would have been worth. So how did this end? Well, D&O insurance covered a lot of this. We're going to come back to D&O insurance tomorrow as one of the methods, or next week. Sorry, you don't have to be here tomorrow. It's always tomorrow to me. It's my next class. It's always tomorrow. We're going to talk about D&O insurance and other methods of exculpation. D&O insurance paid $10 million, and the Pritzkers paid the rest on one condition. The condition was that each of the directors who was getting off the hook contributed 10% to a charity of their choice. And not all of them even did that, just by the way. Not all of them actually even gave the money. Van Gorkom gave an outsized percentage and sort of covered some of them. But yeah, the settlement was a $23 million settlement, which is what the court determined was the amount of sort of underpayment. So takeaways, the board, in addition, needs to become informed. It does not get the protection of the business judgment rule. How do directors become informed such that their decisions are protected? Review of written materials provided before or at a meeting. And so as a result, you get a ton of material. Attention to and participation in deliberations leading up into a vote. And usually those should take place over a matter of days, not hours, for such a major decision. Consideration of information and data generated by persons other than lawyers, like accountants and investment bankers, industry studies, research articles, right? Let's get some real numbers here. And direct communications outside the boardroom to members of management or other directors, right? Going outside the company and really making efforts to become informed. So when we come back, we'll talk about the ways that directors avoid liability, but one way that they avoid liability is through the business judgment rule, a doctrine of judicial abstention, which says that courts will not disrupt a board decision, apparently one that was made with paper and process, one that was made with sufficient information, and where there's not an allegation of disloyalty or illegality or fraud. This doctrine of judicial abstention is most clearly highlighted in Wrigley, and the concept of any rational basis is sufficient for a director's decision to be protected. We saw some reasons for this are ensconced in the nature of corporations and the separation of ownership and control. And we have these major exceptions. In addition to the ones mentioned in Wrigley, that court, if there's no rational basis or if there's fraud, illegality, or conflict of interest, those are exceptions. And now we also have the exception that we are not going to give business judgment rule protection to a board that did not become sufficiently informed. Thank you.